there's claims in a patent, and the claim is what defines the scope of the invention. So patents can have multiple inventors. To put it simply, an inventor is someone who contributes to at least one element of a claim in the patent. Now, when you pay the filing fee for a patent application, it includes 20 claims, a total of 20 claims, 3 independent claims and 17 dependent claims. It's all included in the fee. But as I talked about last time, claims have elements in them. So these can be structure or method steps. But either way, an inventor, the requirements for an inventor is that they have to have contributed to at least one element in a claim. So you could have, let's just say 19 claims where it's only one inventor, but then one inventor might be added that contributed just to one claim. So the 20th claim, say, and there's an element that they contributed. So they might have contributed step G, whereas the first inventor did A, B, C, D, E, F. But if one person contributed G, then they're considered to be also an inventor. Now, it's very important that patent applications, when they're submitted, include all the lawful and all the true and correct inventors. Now, it's important to also note that merely just making a suggestion won't make you an inventor. So if you're in a conference room and you see that your coworkers are working on trying to develop a patent application or an invention, just making some comment, that's probably not going to be enough to make you an inventor on the application. I mean, it might, but probably not. Really, this is about contributing to either reducing some invention to practice, so building something, or meaningfully contributing, whether it's through simulations or design or into the underlying theory that makes the invention work and operate. Now, it's also really important to identify who all the inventors are for another reason aside from being able to have a valid issued patent. Another reason why it's really important to identify all the correct inventors is because each inventor of a patent is considered an owner. So if you have one inventor or a sole inventor, that inventor owns the entirety of that patent. If you have 2 inventors, each is considered to be an owner. So they're joint tenants in common. Now, why is this important? This is important in the context, when you can think about it in the context of a company. So let's just say that you have 2 individuals that are working for company X. So they come up with a product, they develop it out, and then company X wants to file a patent application. So company X employs, let's just say, employee A and employee B. Okay, so as part of their employment agreement, they most likely have an obligation to assign any rights that they have in the patent application to company X. But until they sign the assignment instrument, or until there's some instrument showing that the company is in fact the owner of that patent, the inventors, employee A and employee B, will be the outright owners of that patent and patent application. So it's really important to identify all the inventors, because think about what would happen later. Let's say that there's actually a third inventor, inventor C. So there's A and B, they're listed on the patent application, the patent issues, but then later, let's just say, for example, when the company is being considered and evaluated by investors, maybe for the purposes as a purchasing target. So maybe there's a larger company that wants to buy company X. They're going to do an evaluation and they're going to do their due diligence and study all the patents in their portfolio. Now, think about what happens if during the course of that due diligence, they figure out that there's actually also an inventor C. And inventor C never was listed on that patent. Now, even assuming that they could correct this, but which it is possible to correct inventorship, and there's procedures in place. But remember what I told you, each inventor is considered to be a joint tenant in common and a joint owner of the patent itself. So what that means is that the company X may own the patent, but so does this inventor C. Inventor C may not be an employee, may have never been an employee, and person C could have been, for example, an independent contractor, or another person that didn't have any contractual obligations with company X. So now company X has a problem because there's a third inventor that was never identified, and that in fact is also a joint owner of that patent. If that patent is worth something, then they have serious issues in terms of trying to establish ownership. That is why it is crucial that you understand exactly who all the inventors are in your patent application before you file. And the safest thing to do is to get assignments from all the inventors. So if you're an executive at a company, it's essential that you have employment agreements requiring and assigning the inventor's rights in any intellectual property that's developed while they're employed by the company. And there's actually magical language that you should use in all of your employment agreements to the effect of, as an employee, I hereby assign, I do and hereby assign my rights. And that's been held to be an effective assignment in some cases. And so it's a really, really good idea to, if you're a company executive, to review your employment agreements and confirm that you have language to that effect in your employment agreements. Now, in addition to that, like I said before, if you're a company and you're investing in R&D and you're filing patent applications, it's crucial that you identify in each time you file who all the inventors are, and that you list them in the patent application, obtain signed oaths. We'll talk about oaths in future videos, and also that you obtain signed assignments from them, assigning their rights to your company. Now, this is all part of the patent preparation process, and it's very important that you at least understand the basics of it, just to make sure that your company is in fact the true owner of the entire right to the patent application, and ultimately the patent that it's going to issue.